I was instructed to pray for 3 weeks' time to file an objection in IA.
Learned counsel such as who has made a mention on behalf of the council for respondent number 1, Mr. Im Tiwapang, for 3 weeks' time in order to enable the respondent to file the objection in IA 17 of 2025. So, the appellant is here. Applicant, appellant. The counsel for the appellant / applicant is absent. Stop. List after 3 weeks. Yes.
Much a pleasure.
May please,
Yes,
ma'am.
yes.
I beg to mention hearing item 12 and 13.
12 and 13.
May I pray that this matter may kindly be taken up next week, ma'am. It's our consensus prayer.
Okay.
12 and
prayer
13.
of the parties.
Ah.
This is the matter of next week. Learned counsel for the state respondents, Mr. L.T. Samtam, additional AG is present, as well as the learned counsel, MS such and such for the petitioners. Yes, stop.
Lordship, I'm for respondent 2 and 3.
And Ms. such and such for respondent number 2 and 3. In which item?
Item 12.
In item 12. Okay.
My lord, I'm
This next
praying
week.
for
Yes.
item 12.
Okay, only item 12.
Yes, my lord.
Okay. Yes, only item 12, okay? Yes. Yes.
But respondent 2 and 3.
May I please, Lordship? Lordship, I beg to mention item number 4. Yes, Lordship. Praying for adjournment, Lordship, for 3 weeks, Lordship.
When do you want?
Actually, if possible, in the month of November, Lordship.
So
Last week,
after a month? After
yes,
one?
after.
Also for the, you are for the petitioner?
Yes, Lordship, MJ Gogoi.
Learned counsel for the petitioner, Mr. M.J. Gogoi, praise for
This here.
after a week, after a month, list after. Yes,
Of Lordship.
May I please, your Lordship? Lordship, I beg to mention hearing item number 15 and 16. Kindly let this matter come up after a week.
Meetings are complete. Matter may kindly be
learned counsel, petitioner, message and such, praise for listing the matter after 1 week. So is the
May I please, your Lordship? I'm appearing for respondent number 9 and 10, Lordship, in the said matter, Lordship.
no objection?
No objection, Lordship.
So Ms. Apila Samtam appears for respondent number 10 and learned additional AG, Mr. L.T. Samtam appears for the state respondents. In both,
Yes, my lord.
it's after 1 week. Yes,
Much obliged.
Lordship,
Obliged, Lordship.
I may also be allowed to mention item number 20, admission.
yes.
The engaging counsel is having some personal difficulties today, so can this matter be fixed on 17 October?
This other side is not there. Learned counsel and message and such makes a mention on behalf of the council, leading counsel, Mr. Sintianger. Who?
P. Chanda.
Mr. P. Chanda. Oh, for the respondent.
Yes, for the respondent.
Mr. P. Chanda for the respondent, who has some difficulties today, and praise for listing the matter on 17. On 17/10. So, learned counsel for the petitioner, Mr. Santiago, has no objection. List on 17/10. Yes.
Much a pleasure.
Yes.
May I please, Lordship, please allow me to mention hearing item 17. Here I may be allowed 3 weeks' time to file affidavit in reply to the counter affidavit filed by the respondent.
Learned counsel for the petitioner, Mr. Bakri Chapu, prays for how much time? 2
3
weeks.
weeks.
3 weeks time to file a reply to the counter affidavit of the respondents. So prayer is allowed. Learned counsel for the respondent, Mr. Fosiko Fute is present. Stop list after 3 weeks. Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 2 and 3, Your Lordship.
2 and 3.
Lordship, here pleadings have been completed, Your Lordship. If the matter can come up for hearing on 26th of November, Your Lordship.
26th of November.
Lordship.
26th.
No.
Learned Counsel for the respondent, Mr. M. Solo,
Your Lordship.
who submits that the pleadings are complete and accordingly will be listed for hearing on 26/11/2025. Stop.
Lordship, item number 2 and 3, Your Lordship.
Yes, item 2
Lordship,
and
Your Lordship, that
26.
26 is Wednesday.
Oh, yes. 25th?
25th, Your Lordship.
25th, 25/11. You are for the petitioner?
I'm for the petitioner. I'm appearing on behalf of Mr. Bendawabang, counsel for the CBI.
Learned Counsel, Mr. Fosico is present on behalf of Mr. Bentangwapang for the CBI slash
Valid.
petitioner. List on 25/11. Yes.
Lordship, Lordship.
Lordship, in item 17, there is interim. If it can kindly be extended till the next date.
In item 17, the interim order passed earlier shall continue till the next day. Yes.
Deeply obliged.
May it please your lordship?
Yes.
I'd like to mention hearing item number 13 on behalf of Ali Ralo. There's difficulty today. Kindly list the matter after 3 weeks.
Learned Counsel for the petitioner and such makes a mention on behalf of the leading counsel, Mr. Eli Lalu, who has some difficulties today, and prays for listing the matter after 3 weeks. Stop. Learned Counsel for Learned Government Advocate, Mr. Enangami and Mr. Fosico.
I'm for the private respondents.
For the respondents, and have no objection. List after 3 weeks. Yes.
Okay.
May I please, my lord?
Lordship, beg to mention item number 1.
Lordship, here I am for the respondent number 1, and for the other respondent is represented by Additional AG V. Shokre. Lordship, because of a matter, she is not available today. Lordship, she is attending to a matter in the principal seat. If this matter can be listed after 3 weeks, my lord, I have taken the consent from the other side.
Okay. Learned Counsel for the petitioner, Mr. Arundam is present. Stop. Learned Counsel for respondent number, you are for?
I am for 1, your lordship.
Respondent number 1, Mr. Enangami, submits that the Learned Counsel, Ms. V. Shukre, who is appearing for the other respondents, is engaged in a matter at the principal seat and accordingly prays for listing the matter when?
After 3 weeks, my
After
lord.
3 weeks. Stop. List after 3 weeks as prayed for. Yes.
Lordship, I have a similar prayer for item 7.
Also on behalf of Shukre?
Yes, my lord.
Same is on behalf of Ms. V. Shukre, who's engaged in a case at the principal seat and accordingly released the matter after 3 weeks.
Yes, my lord.
Learned Counsel for the petitioner is present and has no objections. Yes.
Lordship, the item 11, if I may not be causing any inconvenience, your lordship, if this matter can be taken up at 2 o'clock, your lordship, today.
At 2.
At 2, my lord. If they will not be inconvenient to this honorable court, my lord.
Is it a long matter? Will it take time?
I will hardly take 10 minutes, my lord.
What is the matter about?
Matters, Lordship, matters pertaining to land dispute, Lordship.
Land dispute.
Lordship.
At 2? Okay. Let us pass over for the time. Yes.
Deeply obliged, my lord.
For motion from the supplementary cost list, item number 18.
May I place your lordship? The petitioner is aggrieved by an order dated 3/10/2025 passed by Civil Judge Senior Division Dimapur, whereby the learned court below has returned a petition to the counsel for the applicant instead of taking a decision, lordship. In short, I'll take only 5 minutes to state the background. A suit was filed by the present respondents before the Civil Judge Senior Division in Dimapur, claiming ownership over a plot of land and also claiming the rain, claiming for a decree for rain. During the pendency of the suit was filed in 2010.
Okay.
On 2nd August 2019, the plaintiff number 1 expired. After about a year, they have filed substitution application accompanied by continuation application. And that was taken up for hearing on 21st March 2025. Lordship will find at page 64. There, one Mason, who was not the engaged counsel nor authorized by the petitioner, happens to appear allegedly on behalf of the present petitioner. So it was decided, if Lordship look at the application of the applicant, they have not given any proper address. Only the name of the petitioner was shown, no address, nothing. And then no notice was served to neither to the counsel nor to the petitioner. And it was heard on 21st March 2025. And then order was passed. So after coming to know about that order, when the petitioner came to know about it only on 6th of September 2025, after the substitution, he received a notice. Then only he realized that, oh, some order has been passed. So the petitioner filed an application under Order 9, Rule 13, read with Order 22, Rule 10A, read with Section 151 CPC for recalling the ex parte order. And it was heard on 3rd October 2025. And then after perusing the order dated 21st March 2025, the learned court below came to a finding that, look, my predecessor has already heard the counsel and passed the order. I cannot do anything. Therefore, you may approach the appellate forum and then return the petition. Actually,
Basing on the order of 21st March 2020.
yes, and in our application, we have categorically stated that Mason was neither authorized nor engaged by the petitioner. She happens to be a junior, and now we have implemented her as party. On what capacity she has appeared, I don't know.
And she did not raise any objections.
Yes, that's how the order came to be
The
passed.
order was passed.
So the grievance of the petitioner is, let that application which they have filed for restoration and the continuation application, for substitution, let that be heard. I will contest the case by affording opportunity of being heard to me, Lordship. So,
We will have to issue notice.
yes, at this stage, notice may be issued and further proceeding may be suspended for the time being, Lordship, pending return of the notice.
Page 64, and the other order is at page, the impugn order.
90, page 103.
This is an application under Article 227 of the Constitution of India, praying for quashing of the impugn order dated 21/3/2025, passed by the Civil Judge Senior Division, Dimapur, Nagaland, in IA number 32 of 2020 and IA number 33 of 2020, arising out of civil suit number 5 of 2010, and also for quashing of the impugn order dated 3/10/2025, passed by the Civil Judge Senior Division, Dimapur, Nagaland, in civil suit number 5 of 2010. So, the heard learned counsel for the heard learned senior counsel for the petitioner, Mr. Sidi Jamir, assisted by Mr. Im Kong Jamir for the petitioner. It is the the grievance of the petitioner is that the Learned Trial Court has passed the impugned order dated 21/3/2025 without hearing the present petitioner, and that a counsel who had not been appointed or authorized by the present petitioner had appeared before the Learned Trial Court on 21/3/2025. So the petitioner is also aggrieved by the order dated 3/10/2025 passed by the Civil Judge Senior Division, Dimapur, Nagaland, by which the prayer of the petitioner for recall of the order dated 21/3/2025 was rejected. Stop.
Denied.
Was denied.
And then returned the petition.
And the petition was returned.
Second last paragraph.
Yes, and the petition was returned. Stop. Para. Issue notice returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondents.
1 to 5.
Number 1 to 5.
1 to 5.
No, 1 to 6.
1 to 6.
1 to 6.
Yes.
Stop.
Dimapur TC is respondent number
Yes,
7.
Learned Government Advocate Inaudi appears for the respondent number 7. Stop. Records will be required.
Lordship, yes.
Stop. Call for the trial court records from the Court of Civil Judge Senior Division Dimapur. Stop.
Case number may be mentioned, civil suit 5/2010, Lordship.
The records of civil suit 5/2010, okay, may be called from the Court of the Civil Judge Senior Division Dimapur, Nagaland. Stop. Where is your prayer page?
Page 19, Lordship. The interim prayer is at page 19. Lordship has already made observation and that exactly it will be in the same.
Yes. The list after 4 weeks. Stop. In the interim, the operation of the impugned ex parte order dated 21/3/2025, passed in IA 32 of 2020 and IA 33 of 2020, and the impugned order dated 3/10/2025, passed in civil suit 5 of 2010, shall remain state till the next returnable date. Stop.
Much obliged, Lord.
For motion, item number 19.
Yes.
Lordship, the petitioner here is aggrieved by the non-compliance of this honorable court order dated 21/2025, passing WPC 317 of 2024, by which this honorable court gave direction to the respondents, state respondents, to release the petitioner's pending salary, which she has not been receiving since December 2022.
Para 8.
Yes, my lord. And we have served the notice of the court's order. Also, we have served contempt notice. The contempt notice was also replied by the department on 2nd of May 2025, saying that
Saying what?
that things are under process. However, more than 5 months have lapsed even after we have received the reply letter.
Where is that reply?
Annex 4, my lord.
Page 13.
Yes, lordship. Since this is a matter of salary and the petitioner is hardly making ends meet, I have taken this case pro bono, the writ petition as well as these contempt petitions.
This is an application under Section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, alleging willful and deliberate non-compliance of the court, non-compliance of the order of this court dated 21/2025, passed in WPC 317/2024. Stop. This court, by order dated 21/2025, had directed the state respondents to take steps so that the petitioner receives her salary since December 2022 till the date of her retirement on 31/12/2024. Stop. It was further directed that endeavor shall be made so that the petitioner gets her salary within the next 3 months. Stop. The petitioner had also served a notice, contempt notice on the said respondents, which was replied by letter dated 2nd May 2025. Stop. In the letter dated 2nd May 2025, the respondents had replied that the salary payment is currently under process and may take some time as additional fund allocation needs to be obtained for the backlog salary, and her salary will be released in due course of time. Stop. In spite of such assurance, it is stated that the respondents are yet to comply with the order of this court. Stop. Issue notice to the respondents number 1, 2, and 3, returnable within 4 weeks, showing cause as to why they should not be, as to why contempt proceedings should not be initiated against them for violation of the direction of this court dated 21/2025 in the PPC 317/2024. So, the petitioner shall take, learned counsel for the petitioner, Mr. Santiago. So, the petitioner shall take steps for serving notice on the respondents 1, 2, and 3 by.
Registered AD.
No, these days, I believe registered AD is no more there.
My lord.
They have done away with it, and
Okay.
it's called, what is that? Inland post document, something like that. Yes. Stop. And also the usual process, list after 4 weeks.
Deeply obliged, my lord.
For admission, item number 5.
Lordship, if this matter can kindly come up on Thursday, a situation has arisen where it may not be proper for me to take up the case. Subsequent development.
List on Thursday, that is 16, I think, 16, and the prayer of the learned counsel for the petition. Stop. Learned PP and Miss S. Mary is present.
Deeply obliged, my lord.
For admission, item number 6.
May I please, Your Lordship? I may kindly send Your Lordship's indulgence, Your Lordship. In item 14, Your Lordship, I have some personal difficulty today, Lordship. So I've taken the consent from the other parties. This may hearing item 14.
Oh, okay.
This may kindly be listed on 28th October.
28.
28.
28.
Yes. Of October.
Item 14, okay, hearing item. Learned Government Advocate Ms. Nauli has prayed for listing the matter on 28/10/2025 as she has some difficulties today. Learned counsel for the petitioner, Mr. H. Mukam, is present, as well as Mr. Lima Wapang for respondent number 4. So, and he has no objections. So, list on 28 then.
Much obliged, Your Lordship.
Yes.
May it please Your Lordship.
Item 6. Yes.
Lordship, this bail application is filed under section 483 of the BNSS, praying for the release of the accused on bail. Now, my lord, the brief gist of the case is that on 29/08/2025, sumoto FIR was lodged by the narcotic PS to the effect that a joint raid was conducted by the narcotic personnel and the drug control officers, whereby a pharmacy by the name Your Care Pharmacy was raided, and thereupon codeine-based cough syrup bottles and some psychotropic substance or drugs were seized. And thereafter, the accused was booked under 22B and 29 of the NDPS Act.
22C.
22B, my lord. I have inadvertently written C.
Oh, it's written C.
Yes, my lord.
It's
B.
B, actually.
It's B, yes. I have preferred the bail application before the special judge, but the same was rejected by order dated 22/09/2025, my lord. The order is enclosed at Annexure B. So, my lord, my only ground seeking for bail before this honorable court is that there is non-compliance of Article 22(1) of the Constitution of India and Section 48 of the BNSS, as the grounds of arrest of the accused person were never communicated to the relative, friends, or family of the accused persons, my lord. And it is clearly reflected on the last occasion I was directed to produce this order, the first remand order. And my lord, may kindly see at para 3, it is clearly reflected here. The accused person is in good physical condition and has no visible injury. He is informed of the ground of arrest, and family is also intimated of his arrest. So family has been intimated of his arrest, but not ground of arrest. The family members, the relatives were never intimated, were never communicated of the ground of arrest of the accused. Therefore, I am before this honorable court praying for bail of the accused on this ground.
That we will have to see the records. And what did the trial court say? On the other hand, prosecution submitted that the arrest memo is available in the case record shows that the grounds of arrest were duly informed and intimation was sent to the family.
Yes, intimation has been sent to the family about arrest, not ground of arrest, just arrest.
Yes, you have the records.
My lord, I have received the CD, my lord.
So intimation of arrest is one thing and grounds of arrest is another thing.
Yes, my lord.
These are two separate things.
As per the CD, already communicated to your lordship, my kindly.
Communicated?
Yes. Your lordship, may kindly see page number 2. I have highlighted the relevant para.
The accused person was arrested under proper arrest memo. Rights of arrested person was restricted. Okay, as far as accused is concerned, that is done. But I think the allegation here is regarding the family.
Yes, my lord. In the next paragraph, your lordship, kindly see the further intimation of arrest in compliance to under section 48 PNSS was given to wife of the arrested person, Miss So-and-so, with phone number, so and subsequently CD entry was made in narcotic PS registered. Already informed, my lord. And
yes, my lord.
Your lordship,
Intimation of arrest.
yes, your lordship, may kindly see the section 48.
Goza.
Kindly allow me to read, my lord.
48 BNSS.
May I read, my lord?
Yes.
Section 48, obligation of person making arrest to inform about arrest, etc., to relative or friend. Section 48, clause 1. Every police officer or other person making any arrest under the Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other person as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to the designated police officer in the district. The police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. An entry of the fact as to whom has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as the state government may by rules or provided. it shall be the duty of the magistrate before whom such arrested person is produced to satisfy himself that the requirements of subsection 2 and subsection 3 have been complied with in respect of such arrested person. My lord, in subclause 3, it says that if the information, if the arrest of grounds of arrest is explained or given to the relatives, that relative's name should be reflected in the diary, my lord. And here exactly in the city it says that it was communicated to the accused wife, my lord. It is already reflected, my lord. So, my lord, as per the city record, it says that there is no violations of section 48 and 47 of the BNSS.
Yes, Learned Counsel, the requirement of 48
My lord,
is that the information regarding the arrest has to be given information, which has to be given to the relatives, friends, or such other persons. So that has already been given.
yes, my lord.
Yes.
But there is no compliance of Article 22 subclause 1 of the Constitution of India as per Vihan Kumar's judgment, my lord. May I kindly place it on record? My lord, may I kindly turn to para 36, the last page, para 36. And for the convenience of this court, I've marked some portions. May I read, my lord? Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relative, as mentioned above, is not merely a formality, but to enable the detained person to know the reason for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, and nominated persons to secure his release at the earliest possible opportunity for actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the ground of arrest in writing is not only to the arrested person, but also to the relatives, friends, and such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22 subclause 1 of the Constitution meaningful and effective, failing which such arrest may be rendered illegal, my lord. This is
Do you
very
have
clear.
Purkayasta's case also? Following Vihan, another case that Purkayasta was there, no? Justice Sandeep Mehta's case.
No, my lord, I have Vihan Kumar and
Because it is
My
more
lord,
clear in
my
that.
lord, here even the accusers acknowledge that the grounds of arrest has been given to the accused. My lord, kindly see the page number 12.
We
your
are
lords.
not on that, now we are
Yes.
on the relatives, the wife. Because as far as the accused is concerned, they are also not disputing. He has been given,
Yes.
no doubt, the grounds. But to the wife, it was not given. Wife was only intimated about the arrest.
yes, my lord.
And my lord, not only the intimated, but all the documents, FIR, everything was given to the accused wife, my lord, while explaining the grounds of arrest and all.
No, but here it only says intimation of arrest. And then in the court's order also, the remand order, it says he is informed of the grounds of arrest and family is intimated of his arrest. So in the CGM's order also, the order of remand also says that only the grounds of arrest was given to the accused and not to the family.
My lord, in the judgment, in the order given by the special judge, my lord, page number 11, para 6, it says that in view of the above, the contention that the grounds of arrest were not informed to the accused and the family member is not substantiated by the record.
the prima facie, the requirements of Section 48 BNSS appear to have been complied with.
No, but you have to show from the reports, no,
Yes.
that it has been served on the wife.
Yes.
So
My
where
lord,
is that?
In the CD, it clearly mentioned that, Your Lordship, kindly see page number 24.
You have to show the grounds of arrest which have
Yes.
been given with the signature so that the wife has received it. So that has to be there on the record. So that is what is usually done. I've seen in other cases that accused signature, no, that is another thing.
Yes.
Then the wife or relative of the accused with their signature, that is also kept in the CD, the grounds.
Yes. My lord, in the page number 24, Your Lordship, kindly see the CD, my lord, page number 24.
Here also it says intimation only.
Yes.
Accused person was arrested, such and such. Rights of arrested person was read out to him. Grounds of arrest and right to bail was communicated to the accused person in writing. So as far as the accused is concerned, that is fine. You have complied. But here, when you come to the second para, further intimation of arrest was given. That's all. It doesn't say that the grounds of arrest was given to the wife also. It doesn't say anywhere.
Yes, ma'am.
And these things, they are very technical. We have to go by what is written. And if at all the grounds of arrest had been given to the wife, then the police have to obtain her signature and a copy has to be kept in the CD also.
So my lord, my humble submission is, there is no violation of Article 22, Clause 1, and Section 48 PNSS has been complied, my lord. So at this stage, and moreover, my lord, investigation is still under process, so sufficient time may be given to the investigation agency, my lord.
What to do?
That is my humble submission, my lord.
First, learned counsel for the petitioner, Mr. K. Sophie, as well as Mr. Tipapu Leonard PP for the state of Nagaland. Stop. This application under section 483 of the BNSS has been filed, praying for release of the accused, Kevilizo Rupreo, R-U-P-R-E-O, accused Kevilizo Rupreo on bail. Stop. The accused herein has been arrested on, when was he arrested?
29/08/2025.
29/8/2025 in connection with special case number 22 of 2025 arising out of narcotic PS case number 11 of 2025 under section 22 small b and 29 of the NDPS Act 1985. Stop. It is the case of the petitioner that the accused was arrested on 29/8/2025 and is presently lodged at the district jail Kohima. Stop. The accused had filed a bail application being 167 of 2025 before the learned trial court. However, the same was rejected by an order dated 22/9/2025. Stop. The grounds taken by the petitioner herein is that there is nothing on record to show that the grounds of arrest were communicated in writing to the relatives, friends or family of the accused, and there is nothing to show that the same has been received and acknowledged by them, and as such there is gross violation of Article 22, Clause 1 of the Constitution of India and Section 48 BNSS, rendering the arrest of the accused as illegal. Stop. It is submitted by the learned counsel for the petitioner that in the format for information of grounds of arrest, it can be seen that the name of the accused's wife and her phone number has been reflected, comma. However, the same is without any acknowledgement of receipt or signature of the wife. Stop. It is also stated that in the remand order dated 30/8/2025, passed by the learned Chief Judicial Magistrate Kohima, it has been clearly mentioned that the accused has been informed of the grounds of arrest and the family has only been intimated of the arrest. Stop. It has not been mentioned that the family has also been provided with the grounds of arrest. Stop. The learned counsel for the petitioner has relied on the case of Vihan Kumar versus State of Haryana and others, reported in. You don't have the equivalent citation, the SSC citation.
No, my lord.
Okay. Manu, MANU/SC/0161/2025. Stop. Wherein the Honorable Supreme Court has held that you just reproduce this last para 36, this marked portion, okay? Stop. In view of the judgment hereinafter referred to herein above, comma, the learned counsel submits that the requirement of communicating the grounds of arrest in writing is not only to the arrested person but also to the friends, comma, relatives or such other person so as to make the mandate of Article 22, Clause 1 of the Constitution meaningful and effective. Stop. It is therefore prayed that the accused may be released on bail, as the arrest is illegal and against and in violation of Section 48 BNSS. Stop. Learned Public Prosecutor Mr. Tibapom, appearing for the state respondents, has produced the case diary and has taken the court to the entry made in the case diary, wherein it is stated that the accused person was arrested under proper arrest memo, comma, rights of accused person was read out to him in a language understood by him, and grounds of arrest and right to bail under Section 47 BNSS was communicated to the accused person in writing and also read out and explained to him in the language he understands. Stop. Learned PP also states that it is brought out from the case diary that the intimation of arrest in compliance to Section 48 BNSS was given to the wife of the arrested accused person with her phone number. Therefore, learned PP submits that the mandate of Section 48 BNSS has been complied with, and therefore the present petition may be dismissed. Stop. The learned PP has also taken this court to the order of the learned trial court dated 22/9/2025, by which the first bail application of the accused was dismissed. Stop. At para 6 of the order dated 22/9/2025, the learned trial court had observed that the contention that the grounds of arrest were not informed to the accused and the family member is not substantiated by records. Stop. Prima facie, the requirements of Section 48 BNSS appear to have been complied with. Stop. Learned PP therefore submits that the records /CD shows that the wife of the accused person was intimated about the arrest, and all other rights of the accused person was intimated to the wife of the accused person, of the accused arrested person. Stop. Para. This court has given due consideration to the submissions of the learned counsels and have perused the CD which is produced by the learned public prosecutor. So, upon going through the case diary, it is seen that as far as the accused is concerned, the arrest memo, rights of arrested person, grounds of arrest, right to bail, and all other requirements have been communicated to the accused person in writing and also read out and explained to him in the language he understands. Stop. However, as far as the wife of the accused is concerned, there is only a remark that intimation of arrest to the wife under Section 48 BNSS. Stop. There is nothing to show from the records that the grounds of arrest was intimated in writing to the wife also, which is the mandate of Article 22 of the Constitution. Stop. It is the requirement of law that the grounds of arrest have to be intimated to the relative / wife, or to the relative / friends, or such other persons as disclosed or nominated by the arrested person for the purpose of giving such information, according to Section 48 BNSS. Stop. It is also a requirement of law that such grounds of arrest in writing have to be acknowledged and signed by the wife / relative, and the same has to be on record. Stop. This court is unable to find any such record of receipt of the grounds of arrest from the wife / relative of the arrested person. Stop. In view of the above observations and discussions, this court is of the view that the requirement of Section 48 BNSS and the mandate of Article 22, Clause 1 of the Constitution has been violated in the present case. So, accordingly, the petition is allowed. So, the accused what's his name, accused
Civilians or review.
Kevilizo Rupio is hereby released on bail on the following terms and conditions. Number one, execution of bail bond of rupees 30,000 with one surety of like amount, who shall be a permanent resident of Kohima, to the satisfaction of the learned trial court. Step number two, the accused shall not hamper the investigation or tamper with the evidence in any manner, and shall appear before the IO as and when summoned. Stop. Next, the accused shall not leave the jurisdiction of the trial court without permission from the court. Stop. Any other conditions you want to put?
That will suffice, my lord.
With the above directions, this petition stands disposed.
Much obliged.
Obliged, my lord.
For orders, item number 9.
May I please, Lordship?
Yes.
Lordship, by order dated 25/09/2025, Lordship, this court directed the appellant to serve notice upon respondent 2 and 3 through paper publication, Lordship. So the publication was done on 09/10/2025, and with effect to that, I filed my affidavit on 09/10/2025, Lordship.
So now we can take it as deemed served, since nobody has appeared today.
Lordship.
Yes, my lady.
When did you publish?
Published on 19/09/2025.
19 September.
Lordship.
19 September. Today is already the 14th. Stop. Learned counsel for the petitioner. Petitioner/appellant, Mr. Such and such present. Stop. It is stated that this court, by order dated 25/8/2025, had allowed the petitioner to take steps for notice upon the respondent number 2 and 3 by substituted notice by way of publishing in 2 local newspapers. Stop. In compliance of the order dated 25/8/2025, the appellant has taken steps and the newspaper publication has been made on 19/9/2025, and an affidavit to the same has been filed by the appellant. So, accordingly, the notice on respondent number 2 and 3 is deemed served. Stop. You are appearing for?
I'm for the claimant,
Okay.
claimant respondent.
Okay. Mr. Rosiko Forte appears for the claimant respondent number 1.
No.
Respondent number 1. Stop. So now this was for condonation of delay. Was it this?
Lordship. There has been a delay of 33 days, Lordship.
Are you objecting?
Lordship,
Okay.
in respect of delay, I leave it to your Lordship.
Let us condone and then admit it.
If Lordship is satisfied with the
Yes.
submissions made by the
33 days.
my lady.
Your reasons, where is it stated? Para?
Page 6, para 12. Para 12, Lordship.
This order is in IA 51, okay? Para. This application under Section 5 of the Indian Limitation Act 1963 is filed praying for condonation of 33 days in filing the connected MSc appeal. Stop. The applicant has stated that the appellant has a divisional office at Dimapur in the state of Nagaland. and it has a regional office in Gauhati, Assam. Stop. The appellant had received the judgment dated 9/12/2024 only on 15/1/2025 through its counsel, and it was thereafter forwarded to the regional office for verifying, and the same was returned to the divisional office at Dimapur with the advice to file an appeal at the Gauhati High Court Kohima bench on 27/2/2025. Stop. On 4/3/2025, the company slash appellant appointed Miss Sedinguno, Sedengunuo, Pienyu, to present the case at the Gauhati High Court Kohima bench, and the file was received by the said council on 10/3/2025. Stop. Thereafter, the council furnished her legal opinion and returned the file along with the draft petition to the company slash appellant on 19/3/2025 to obtain signature and necessary formalities. Stop. Thereafter, the regional office Gauhati, Assam, after putting the signatures in the affidavits, returned the file to its divisional office in Dimapur on 8/4/2025. Thereafter, subsequently, the instant appeal was filed on, what is this? Filed on?
11/04/2025, Lordship.
No, date of filing is 14. Was filed on 14/4/2023, thus causing a delay of 33 days in filing the connected appeal. Stop. It is submitted that the delay has been caused due to the reasons stated above, and not due to any willful negligence or default on the part of the appellants, and as such, it is prayed that the delay of 33 days may be condoned and the appeal may be admitted for hearing. Stop. Learned Counsel, Mr. Fusiko Forte, for the respondent number 1, has not objected and has prayed that instead the appeal may be admitted and it may be heard on merits. Stop. This court has gone through the application of the appellant and is satisfied that there was sufficient cause given for the delay. So, accordingly, the delay of 33 days is condoned and the application is allowed. So, the petition stands disposed. Then you come to main appeal, okay, MSC 4.
Lordship, there's another IA. IA is for stay.
IA is for?
Stay.
Stay.
Is for
52.
stay.
IA 52 is for stay.
My lady, my prayer is if this honorable court will be staying the impeachment order, then if subject to deposit of at least 50% of the award.
First, we will go to this main appeal. Okay, in
My
view of the order passed in IA 51 of 2025, the present appeal is admitted. Stop. Call for the records of MSC number 77 of 2014 from the court of the from the Motor Accident Claims Tribunal, Dimapur, Nagaland. Stop. And list upon receipt of the trial court records. Stop. Then in this also you give the council's names, learned counsel such and such for the appellant and learned counsel for Seco for the respondent number 1 is present. Then in IA is 52 of 2025. Then third learned counsel for the petitioner, Mr. Such and such, as well as learned counsel for respondent number 1, Mr. Fosico Fote. Stop. Para. The present application has been filed praying for stay of the impugned judgment and award dated 9/12/2024, passed by the learned MACT Dimapur, Nagaland, in MAC case number 77 of 2017, pending disposal of the connected MAC appeal 4 of 2025. Stop. The submission of the learned counsel for the appellant is that the main appeal number 4 of 2025 has been admitted, and there are reasonable grounds which have been put forth for the appellant. And the appellant is hopeful that the appeal will succeed, and therefore it is prayed that the judgment and award, the impugned judgment and award dated 9/12/2024, passed by the learned MACT Dimapur, Nagaland, in MAC case number 77 of 2014, may be stayed pending disposal of the appeal, inasmuch as the applicant/appellant has a prima facie case in the said appeal, in the said connected appeal. Stop. In view of the submissions made above, this court is inclined to stay the operation of the said impugned judgment and award dated 9/12/2024, passed in MAC case number 77 of 2014, on the condition, subject to the condition that the appellant shall deposit 50% of the awarded amount before the registry of this court within how much time? 60 days.
Lordship.
30 days. 60 days
30
is too
days.
long.
Within 30 days from the date of this order.
And Lordship, my lady, if on verification, if it's fine or correct, then the claim.
No, when they deposit, you file a separate application for
My lady.
withdrawal. Okay.
No, my lady. My lady may be pleased to call for the tribunal's record in the main
We
appeal.
have already called, isn't it? Trial court records in the main appeal in MSC 4. Yes, yes.
Highly obliged.
For orders, item number 10.
Your Lordship, the notice is still awaited, Lordship.
R1 returned unserved. Insufficient address.
So Lordship, allowed me some time
You
to
will have to verify.
verify the address. If I may, Lordship, there is a typical error in the cost title. Here it is stated that judgment appeal section under 173 of the Motor Vehicle Act 1988 against judgment and award dated issued with 22/04/2025. But here is written 28/0/2025 in the cost title.
Course title of the IA.
In the main appeal. Lordship.
Judgment date is wrongly inserted.
Yes. So allowed me to.
You fill it up by hand and then put your signature. I will just give a direction.
Lordship, if that is the case.
Only the date, na?
Yes, indeed.
Okay.
And Lordship, also page 2, the MAC appeal case number, it should be 16 of 2024. Here it has written 1/1/2016. So that also,
In that case, you file an IA for amendment of the course title.
Lordship.
Okay.
Okay, Lordship.
Okay, in IA 164, learned counsel for the appellant, Mr. Sajin is present. Stop. The office note dated 3/10/2025 indicates that notice to respondent number 1 has returned unserved with the remark insufficient address. Stop. The appellant / applicant shall verify the proper address and take fresh steps. Stop. List after 4 weeks. Then in the main appeal, MSC 18, learned counsel for the applicant, for the appellant submits that there is a typographical error in the course title, and accordingly prays that he may be allowed to file an IA for amendment of the course title. Stop. Prayer is allowed. The appellant shall file the same within 2 weeks. Yes. And list the matter after 3 weeks. Oh, that was a 2. Okay.
Pretty 100 plus. Number more than 1,000. Something like here. Something like here. Then communicate here. Sheep, her. You know, typing out there. I used to grow flowers. Baru di situ kan? Dengan talapan logo party itu. Oh, saya puasa. Ah. Laki. Usia.